Hello everyone, this is Brian Ka with another video. So in this video, I wanted to do a past remedies essay from February 2013. The reason why I am doing this is because I am finishing up a remedies class in my law school as a third year first trimester student. And while it's fresh in my memory, I thought that it'd be a good idea to share how I would go about attacking this question. I'm not saying that my explanation here is a 90 answer. My goal is to just share my mode of thinking, how my brain tries to do this problem from the beginning to the end, and hopefully you'll get a good idea on how other people may approach this problem. And some of you may already do this question, have done this question, and can probably do it a lot better than I can. The point again is not to say that, hey, this is a better answer than you. Not saying that at all. What I'm trying to do again is to show you how other people would approach this question and how they would go about resolving the questions at hand. So let's talk about this. And as you can see, I've invested a little bit into this microphone. It was a unbelievable deal. It was $5 on Amazon. There were like $100 microphones, but I am not in a position to buy those. So I invested $5 into this little teeny weeny microphone, and I did this because going forward, I want people to understand what I'm saying better, hear me better, and I'm doing it because of you. And I also found this whiteboard for free on OfferUp. I think the person offered it for like $5, and I counter offered, since we're in law school, I counter offered $3, and she just said, you know what, come take it. So I drove, I think like 10 miles, maybe less, to pick it up. It's a little bit old, but it's gonna achieve its purpose, and trying to communicate what I'm trying to say, since I don't have a digital whiteboard and I'm speaking through a telephone, because I feel like this is more comfortable and it's easier for me to just hit record rather than going through a program and going through all those little things. And I just want to simplify things. So here I am with a new mic, $5, a new whiteboard, free, to hopefully help you. And if you're stuck in remedies, or if you just don't understand it, I think that this would be a good video for you. So let's talk about February 2013. So in 2004, Mary and Frank, they orally agreed to jointly purchase a small storefront space in city for $80,000. Okay, so we have two parties. Mary and Frank. They orally agreed Now, whenever this oral agreement comes out, usually in contracts, that translates to a statute of frauds issue, right? Meaning, as you probably know, any contracts, $500 or more, marriage contracts, real estate, things like that, has to be in writing, correct? So I'm not sure where this problem is going to trigger statute of frauds, but let's just write it. I realize that I need to write bigger because you can barely see it. Okay, so statute of SOF, possible. Okay, possibly statute of frauds, right? So how much did they contribute? Mary contributed. Mary here, or should you write? Okay, 40,000, right? 40,000, and Tanner, although it was embezzled money, contributed the same amount to money, 40,000. So let's go here. 40,000. Right? Okay. So the small storefront space was 80,000. So this obviously $80,000, and that's how they bought this small storefront space, right? The thing is, their agreement was to put the property in Frank's name alone, right? So the first thing is Frank's name. I guess I wanted to say only, and that's I guess we can call that title. Frank's name only title. The reason why they did that is because Mary had creditors seeking to enforce debts against her. So is that going to be an issue? Possibly, because when you're trying to, if Tanner is trying to argue for defenses, I guess they can later say you had unclean hands, meaning, this contract, you're also at fault. So because you're at fault, what you're arguing can't be established. So I guess second thing you can say is Mary had creditors. Well, possibly unclean hands. Right? So this could be an issue. Title issue, I'm not too sure yet. Let's get into it and talk about it. Okay, so Mary had creditors seeking to enforce debts against her. They further agreed that Frank would occupy the property, which he planned to use as an art studio and gallery. They also agreed that if and when he vacated the property, he would sell it and give her 1/2 of the net proceeds. He then occupied the property. Okay. He would sell it and give her. So this agreement, 40,000 plus 40,000, 80,000 purchase price, rested on the fact that when when selling, when sold, they would split one half plus one half. All right, so we get the picture now. So they got into an agreement, 40,000, 40,000, 80,000 total. If sold, they're gonna split it one half each, right? Oral agreement, possible statute of frauds. It was in Frank's name only. Mary had creditors, possible unclean hands issue. So going on. So in 2005, Tanner discovered Frank's. I think I had Tanner and Frank mixed up. This is Frank. Frank is the one that got into this deal with Mary. So right. And Tanner was the one that lost money because Frank embezzled money from him. So in 2005, Tanner discovered Frank's embezzlement and fired him, right? I don't know if that's a big issue, but okay. So in 2012, Frank sold. For how much? 300,000. Okay. So they invested 80,000, 40,000 Mary, 40,000 Frank, and then he sold it for 300,000. The promise was that when they split it or when they sell it, each person was supposed to get one half. So Mary was supposed to get 150,000, correct? But Frank only offered to repay Mary the original 40,000, which was a breach, you know. And Mary demanded what was promised, which was $150,000. So the problem arises now. Mary and Tanner. So let's go here. Mary and Tanner sues Frank for conversion. Okay, for conversion, right? And the trial said that Frank was liable. So the first thing that I should have done, I kind of talked about this in my last video, is I should have read the questions, the call of the questions first. In all of my essays that I do now, I read the call of the question first before reading the facts. So in this question, what we should have done, or I should have done, was to read the call of the question and try to figure out what they're looking for. So what was the call of the question? So remedies. Number one is remedies. versus Frank. And defenses. That's number one. What remedies can Mary argue or reasonably obtain against Frank for conversion, and what defenses? Number two, another remedies. And this is Tanner. Tanner versus Frank. And defenses, right? I hope you can see all that. And that's basically the question. One thing about remedies is I feel like it's the most specific subject, meaning they ask you exactly what they want. I've seen some model answer questions or model answers. When they asked about remedies, they went into, I think this was a contracts remedies question. They went into the whole, is this UCC or common law, because it was a contract breach question. And then it went into offer acceptance consideration, went into the whole, contracts analysis. But I feel like unless the question is asking you for whether there was a breach, analyze, or will Mary prevail under this theory, then maybe you can talk about that. But unless, they're asking you for that type of question, I think it would be wiser to just focus your attention on remedies. In this situation, they're telling you that the trial already happened and Frank was liable. He lost. So it's not the matter of whether Frank should be liable for conversion. Was he substantially deprived of his possession, thereby owing whether a cost of repair, was it like a trespass for chattel versus the fair market value at the time or place that this breach or conversion happened. That's not the question. I think a lot of students, even myself, we get trapped into analyzing whether there was a conversion. Again, this is not a conversion analysis question. They're telling you conversion already happened. What they're asking you is, after the trial, what kind of remedies, or easily put, what can you get from the loser, who was Frank in this case, right? He was the defendant. Although they're asking you for defenses also, right? So, okay. I'll get better at spacing this whiteboard. Right now, this is my first time, so I don't have that much space. So what should we do? I think we should leave that, and I think we can just get rid of here. All right. Okay, so we have two questions right here. I guess we can get rid of this after we analyze. So, remedies to me is one of the easier subjects. Why? Because they tell you that the defendant is liable, and then they basically tell you whether this was a contractual breach or whether this was a tort. Now, in this question, conversion, right? So, as you probably remember from torts, conversion is a tort, so this is a tort remedy question. Right, tort. Now, after figuring out that this is a tort remedy question, the things that you have to, that should go in through your brain is, okay, we have to talk about things like compensatory, right? If it applies, talk about consequential. As you probably remember, this compensatory is to make the plaintiff whole, right? Or in contracts, it would be what the plaintiff would have received had the contract not been breached. But since this is a tort, and usually for conversion, this is easy because conversion is usually for compensatory. It's fair. I can't believe I have all these memorized. I should memorize more, but I do have them memorized, like the basis of it. Fair market value of the property at the time, at the place that conversion happened. Time plus place. Right? So that would be under compensatory. Now, when you're talking about consequential, I guess you can talk about whether it was foreseeable, because you have to have, proximate cause and actual cause. Was it certain? That's another thing. Causation, certainty, and foreseeability. And usually they talk about mitigation, right? Mitigation. Okay. And then for torts, you can also talk about things like incidentals. And then you can talk about restitution if it applies. The important thing here is this guy, Frank, has $300,000 in his hand, right? And let's say our client, Mary, had a promise with this guy who has $300,000 that she would be owed $150,000. So how do we get, under what theories do we get this, or half of it, back to our client? That's the question, right? Now, I talked about this because that should be in your brain memorized, because whenever you see torts question, it should automatically trigger, okay, compensatory, consequential, incidentals, restitution, know all the elements. Also know the equitable remedies, meaning here can talk about first constructive trust, equitable lien, and I think that because in this scenario, this is not an injury case. This is a case where we have to not steal, but we have to take that money from this dude who has 300,000, who promised our client $150,000, and our client is owed $150,000. So the best way to take this money back would be under equitable remedies, under torts, right? And we talked about these two, constructive trust and equitable lien, right? So on the essay, I would go right into, remedies, and I would go right into constructive trust. And in order to do that, you have to know what constructive trust is, right? Or you can't write. So constructive trust would be defendant was unjustly enriched, right? That's where constructive trust falls under. And I guess you can talk about things like, the defendant will hold the money. He has 300,000. As a trustee, I'm sure you've taken wills and trusts, but because he was unjustly enriched, court will order him to hold $300,000 so that he can pay out our client Mary. But the thing about constructive trust, you always have to remember, is that there is a issue of tracing, right? So can this $300,000 be traced from that 40,000 that Mary paid? Yes, because Mary put down 40,000. Frank put down 40,000. That was 80,000, and that's what became 300,000 because Frank ended up selling the property for 300,000. So he was unjustly enriched, and the property value went up, what, $220,000, right? So you have to talk about, I would talk about first constructive trust. I will talk about constructive trust. Make sure you know all the elements. Tracing, unjustly enriched. The third thing you should know is if there is an increase in value, does Mary get the increase? Under constructive trust, she does, right? So right now, it's $300,000. It went from 40,000 to 300,000. So she's owed $150,000, right? Another way to look at it is because they already had an agreement which was to split the proceeds, $300,000, into halves. So our client can argue under constructive trust here, $150,000. And another thing that you need to know for constructive trust is it can be ex parte, meaning you don't have to notify the opposing counsel that you're going to claim 150,000. No, that's TRO. I'm sorry, that's TRO. So I guess unjustly enriched, court allows tracing. Plaintiff can argue for increase in value, $150,000, but that was what she was promised by Frank. So I would first start with constructive trust. Now, here I wrote equitable lien, and that's another theory that you can under torts, under unjust enrichment restitution. So here, I would write the same thing, unjustly enriched, court allows tracing. Only difference is that the plaintiff doesn't get the increase in value, because for equitable liens, that's why it's different. So under this scenario, because she was already promised $150,000. All right, let me get another mic. This is. Okay. So it's the same thing under equitable lien, except for the fact that the plaintiff doesn't get the increase in value, right? They can argue to get 40,000 because that's how much she invested in the beginning, and because she doesn't get increase in value, she can't argue for 150. However, the model answer, I guess, said that because they already had an agreement, which was to split the costs or the proceeds into half, I guess you can mention under equitable lien here that the plaintiff doesn't get the increase in cost, but because she was owed 150,000, one half of whatever proceeds they made, under equitable lien, she also can argue for $150,000. So under tort, we already have two theories: constructive trust, equitable lien. And another thing, I guess, you can argue is, I guess, specific performance plus replevin, meaning you're kicking somebody out because I own that property, right? But if you really think about it, specific performance and replevin is a little bit difficult here, because he doesn't own that property anymore, right? He's just left with $300,000 in cash because he also doesn't have that property in his possession. The theory of replevin wouldn't work either, because that's a lawsuit that you can initiate to kick somebody out. But because he's not in possession of that property anymore, this wouldn't work either. If you want to go into specific performance, I guess you can, analyze it and, go from specific performance, replevin. Go from, was there a valid contract? Go into inadequate legal damages to, you can get into mutuality. Is it feasible? Because those are the elements, right? But here, specific performance, because that would be like, trying to get his money back, and you're not ordering the court to, give him back his land, because we all learned that getting back land is because land is unique, and specific performance happens under that scenario. But because he's already sold it and he profited, he has $300,000 in his pocket, and what we're trying to do is to, get that back. So I would talk about constructive trust, equitable, lien as the main. Kind of talk about specific performance, replevin, and I guess you can talk about legal damages, meaning under legal damages, which means money. I wouldn't go really into it, but I guess I would talk about he was unjustly enriched. He was supposed to, she was supposed to get one half of the proceeds, and she didn't. But, that wouldn't be as strong as arguing under constructive trust and equitable lien, in my opinion. So I would just, briefly touch upon that theory, legal damages, briefly talk about replevin, talk about specific performance. But the main thing here in this question would be constructive trust and equitable lien. And in order for you to obviously talk about these two theories, you have to know the elements cold. I think I kind of got stuck here because I was getting confused with temporary restraining order, but we're not talking about temporary restraining order here. We're talking about constructive trust, right? And remember, for number one, they also asked for defenses, and this is when we had this up here somewhere, but this is when you can talk about defenses for Frank, statute of frauds. It was an oral contract, and because it was not in writing, this contract is not valid. I guess that's something that you can mention, because this was a real estate contract. This was an oral agreement, so Frank can counter saying, this is, not enforceable because this was not in writing, and that violates statute of frauds. Another thing is, I guess Frank can argue unclean hands because, Mary had creditors, chasing after her, and that's why she didn't put the real estate under her name. She only put it in Frank's name to avoid creditors. So that's another thing. Defense is unclean hands, right? So that's another way to do number one. Now we can quickly do number two. So here we're talking about Tanner versus Frank, and Tanner was Frank's employer, and Frank embezzled money, right? So the 40,000 was what was embezzled from Tanner, and this eventually became 300,000, right? So if you're representing Tanner, how would you take what he's owed with this in Frank's pocket? Well, it's the same analysis. Talk about constructive trust. And we already talked about unjustly enriched. Court allows tracing. And he can argue for the increase in value. This is important because unlike Mary, who had a bilateral oral contract saying, hey, the proceeds, we're going to split that into halves. In this case, for Tanner didn't have that bilateral contract oral agreement. So in legal damages, I guess Tanner can argue for 40,000, but when it comes to constructive trust, unjust enrichment, whereby defendant becomes the trustee, and the court orders the trustee to pay out Tanner, because that money can be traced. That 40,000 that he embezzled can be traced to the $300,000 he has, and he can argue for increase in value. So because it was 150,000 owed to Mary, so what's left is $150,000. So that increase would be what? 40,000 plus right, 110,000. That would be 150,000. So under constructive trust, Tanner can argue for 150,000, right? Now under equitable lien, it's the same pattern, except that he can't argue for increase in value. The most he can argue for is 40,000. But if he doesn't get the 40,000, bar model answers love to talk about, if he doesn't get the 40,000 under equitable lien, then he can initiate another lawsuit to make up for that loss. And I've seen a lot of model answers that talk about this. So he can argue for 40,000 under equitable lien, but most likely I would say like something like, because under equitable lien, he's not allowed to argue past 40,000, only the amount that he lost to make him whole. Most likely he will go for constructive trust theory, and that would make him, whole, meaning that would give him 40,000 that he lost by embezzlement plus 110,000, which was an increase in value, and under constructive trust, that's allowed, right? Now, other than that, let's see, did I miss anything? I guess for legal damages, do I want to talk about it? I don't think that talking about legal damages would be wrong here, but I think what this question was asking for are basically the equitable remedies, which are constructive trust, equitable lien. We talked about replevin, we talked about restitution, we talked about specific performance, although I don't think you need to go into that. Also, for question number 2, we talked about these 2 theories on how to get this money back. And I guess you can talk about, under restitution theory, legal damages, he lost 40,000, but, under traditional restitution theory, there's no increase in value. So the maximum amount of money that you want to get for your client would be under the constructive trust theory. So I would go into this and explain that for question number 2, that would be the ideal route to make our client whole. And remember, they also ask for defenses. So for defenses under question number 2, I always see a pattern for remedies. It's usually always 2 defenses. It's always unclean hands. We already talked about that for question number 1. So the other one that's left is latches. When a delay unreasonably prejudices the client or the plaintiff, then the plaintiff is also at fault, and that defense would work. So I would briefly talk about latches. Just to show the bar graders that, hey, I know for remedies there are 2 major defenses. I talked about unclean hands in the first question. Second question, I talk about latches. So I think for February 2013 question, this should be sufficient. Obviously, you're going to have to know how to apply the facts to the rules, and obviously knowing the rules is not enough. And if you have this question in front of you, obviously you want to make sure to use the facts, and under each theory you want to go through each element, apply them to facts, and that's how you're going to score points. But I think as far as outlining this particular question, I think this should be sufficient. I think one thing that I forgot is that for conversion, I already talked about this earlier. It's not for compensatory. It's not usually, the damages like injury damages. It's usually uh, the loss in value or fair market value at the time and place when the tort occurred, when conversion occurred. So that would be the right way to talk about compensatory here. But again, the damages here weren't focused on compensatory, even though you could probably talk about it. The main thing here was equitable remedies, talk about constructive trust, talk about equitable lien, know the elements for those two theories, cold, you have to know it. And then talk about it, also specific performance, know the defenses, latches, unclean hands. And same thing for number two. It was just a little different, but the main difference is that the second question, the plaintiff didn't have a oral agreement. He was the victim of an embezzlement scheme. But because he lost 40,000 and we want him to get more, we were able to say that because under constructive trust, the plaintiff is allowed to ask for the increase in value of what he lost. So even though he initially lost $40,000 from embezzlement, he deserves to get $150,000 because that's the increase in value. That was $300,000 minus what Mary was owed, so that was $150,000. Under equitable lien, he can't ask for $150,000. Maybe he can ask for, but the facts don't really say that he lost money in other ways. They basically just said he lost $40,000 from the embezzlement. So the second equitable lien, he can only ask for $40,000. If it goes lower, then he takes the lower amount. He can't, that's one thing about equitable lien that's not as good as constructive trust, is that he needs to, bear the increase or decrease in the value of what he lost. So, I would say that, it is probably, better for the second plaintiff to go after the second theory, the equitable lien theory, as opposed to going after constructive trust. So I know this was a little different. Maybe I can organize it better next time. But everything takes practice. And, even this, trying to talk about this question and explaining it, takes practice. So hopefully I'll get better at it. But I hope that you got something out of this. If you're struggling with, remedies, I hope this video was helpful to you. And I am planning to talk about more remedies and wills and trusts before this trimester ends. So while it's fresh, I can regurgitate it and, share some, insight. I'm sure that some of you can do this question a lot better than I can. But where I stand as where I am right now in my, educational capacity, this, is the best I can do. And I think that, as long as I can flush out the facts to those, that outline, I think that it would be a 65 at least. I'm not even aiming for a 70, as long as it's like 65, 70, C minus, a passing score, then I don't need a 80, 75, so yeah, so I hope that was helpful to you, and I'll see you in the next video.